We call the case of Ron Wood versus Graycon Suisse, S.A. For argument today. Is the appellant prepared to proceed?
Yes, Your Honor. May it please the Court. At this time, I'd like to reserve 2 minutes for rebuttal. My name is Austin Byram. My co-counsel is Jeff Gunnell, and together we represent the plaintiff appellant, Professor Ryan Wood. There are 2 issues before the Court today. 1, whether removal was proper under Section 1441 despite the presence of a forum defendant, and 2, whether the stream of commerce approach should apply to determine personal jurisdiction. I will discuss the first issue, while my co-counsel will discuss the second. There are 2 reasons that this Court should reverse the District Court of Texoma. 1, the so-called plain meaning approach actually violates congressional intent, and 2, the plain meaning of Section 1441 requires service prior to removal. Powerful companies across the country employ the controversial tactic of snap removal to avoid litigation in state court. These companies employ snap removal by monitoring electronic dockets and removing the case prior to the plaintiff having the opportunity to serve. Thus, they manipulate the forum defendant rule, a limitation upon federal diversity jurisdiction, to exploit a loophole and avoid federal court altogether. Now, this violates congressional intent. The Supreme Court has said that the purpose of federal diversity jurisdiction is to avoid possible bias towards an out-of-state defendant in state court.
Well, the way you couch the issue, though, that you essentially concede that the plain meaning of the statute requires proper joinder and service, does it not?
Your Honor, the plain meaning of the statute does not require proper joinder of service. The plain meaning approach is the line of reasoning that district courts have used to come to that conclusion. However, as I will show, that reasoning is faulty.
Well, I understood your first signpost to be that the plain meaning approach violates congressional intent. How else am I supposed to discern congressional intent other than the ordinary meaning of the language that Congress uses? That's how they tell me what they intend.
Well, Your Honor, if the plain meaning of the statute is ambiguous, then courts can turn to canons of construction to determine what the congressional intent was.
So does your argument depend upon my agreeing that the statute is ambiguous?
No, Your Honor, because alternatively, if you do not find the statute to be ambiguous, the plain meaning of Section 1441 does require service upon at least one defendant prior to removal, which is my second point. Returning to my first point, once a forum citizen defendant has been named in the case, the purpose of federal diversity jurisdiction no longer applies. Now, this is important and is established in Section 1441, which is a limitation upon federal diversity jurisdiction, the forum defendant rule. Now, in 1948, Congress added the words properly joined and served to address a specific issue, that of fraudulent joinder. Plaintiffs were fraudulently joining forum state defendants in order to
Why do you need the served language to deal with fraudulent joinder of defendants? Does whether or not a defendant is fraudulently joined turn upon whether or not the defendant has been served? It's the and served language that's your problem, not the properly joined part. So why in 1948 did Congress put in the and served phrase? What's the work of that language?
Your Honor, the purpose of that language, as discussed in the second point, is to require at least one party to have been joined and served. That is why they included the word served in that clause. Now, the forum defendant rule is designed to keep these cases where there's a forum defendant in state court. The fraudulent joinder rule is to address fraudulent joinder. However, forum defendants, as late as the 1990s, began manipulating the forum defendant rule to turn it and transform it from a limitation upon federal diversity into a loophole that they can exploit to avoid federal diversity altogether.
So then along comes the Jurisdiction, Venue, and Clarification Act, in which Congress, as you've said, the late 1990s, manipulating the forum defendant rule. The snap removal issue predates the the Jurisdiction, Venue, and Clarification Act, and Congress didn't eliminate the "and served" language. So doesn't that reflect congressional intent, that language, Congress meant what it said the first time?
No, Your Honor, it does not. As Breitweiser addresses, the district court district courts across the country in addressing the issue of SNAP removal were deeply divided over which interpretation to follow. Thus, when Congress amended the issue, or when they ratified the statute, they did not clarify that deep divide across the country. Thus, the 2011 amendment in the Jurisdiction Venue Act does not actually say whether or not Congress intends for the plain meaning approach to follow or the absurd results approach to follow. Now, the 2011 amendment
You call this result absurd. Plaintiffs could have filed this case in federal court initially, right?
Yes, Your Honor.
There's
that is
complete
correct.
diversity of citizenship. Plaintiffs could have filed this case in federal court, and that would have been consistent with Article 3 and 1332, right?
Yes, Your Honor.
So why is it absurd that we're now in federal court?
Well, Your Honor, the plaintiff is the master of their complaint, and if the plaintiff chooses to be in state court, that is their decision. What the SNAP removal tactic does is it deprives the plaintiff of the opportunity to be the master of their complaint by creating...
What case has ever held that a plaintiff is the master of its complaint in the sense that you're talking about? That it gets to hold a jurisdiction in a state court because that's where it filed. Isn't that the point of allowing a defendant to remove? Well, you made a bold statement there. I want to know if you have any case to back it up.
Specifically, Your Honor, whether or not courts hold that the SNAP removal deprives them...
No, sir. Whether or not you said the plaintiff is the master. I certainly am aware jurisdictionally between California and Texas that every one of us has made that argument in both directions. What I want to know is where a case that says any deference should be given to the plaintiff's decision to file in state court when a case is properly removable. What discretion should we give at all to the plaintiff in that situation?
Well, Your Honor, the United States Supreme Court in Shamrock Oil and Gas v. Sheets discusses whether or not plaintiffs have the opportunity whether removal should be construed strictly in favor of the plaintiff due to their being the master of the complaint. And the court did find that removal statutes are to be construed strictly. Whether or not they did not hold specifically that it deprives them of their ability to be master of the complaint. However, in light of the fact that removal statutes are to be removed strictly, we ought to infer that Congress intends Section 1441, this language, to be construed strictly in favor of keeping this case in state court. And, Your Honor, essentially what SNAP removal does is it turns a limitation upon diversity jurisdiction into a loophole that creates a race to the courthouse. Who wins?
Counsel, I have a question. You
Yes,
keep
Your
talking about absurd results, manipulation, almost as though it's conniving, loopholes are bad, etc. This justice has a father who financed my education based upon the income he received as a CPA to help clients figure out how to take advantage of the U.S. tax system. What is wrong with a defendant taking advantage of the express words in the statute and using it to its advantage in this circumstance?
Your Honor, there is nothing wrong with a defendant playing by the rules of Congress. However, there is something wrong when a defendant takes advantage of the rules and violates the intent of Congress. Courts are to interpret this statute consistent with congressional intent. Congress is not trying to set up a rule that favors only the powerful companies who have the ability to monitor these state dockets and immediately remove upon a plaintiff being served.
Well, my brother can protect his own question, but where do you divine this congressional intent from? I mean, I read the statute, and as we've already said, there was no modification to the language "and served." So we're not in the business of divining intent. We're in the business of reading the language that Congress set forth.
Yes, Your Honor. In 2011, Congress did amend the statute, and while they did not change the words "and served," they did change the word none to any. So the statute now reads, if any of the parties at interest are properly joined and served and are a citizen of that state, removal is not proper. Now this is important because when courts are reviewing the word any, there's a canon of construction that allows them to consider that expansively. Now the word any specifically means one or some of a kind. Thus, it could be fairly read to say that one or some of the defendants who have been properly joined and served, then that triggers the time for the judge to review whether or not there's a formed defendant in the case. However, the interpretation of the plain meaning approach, which is that removal is not effective unless a formed defendant has been properly joined and served, seeks to advocate that regardless of whether someone has been served, no defendant could be served. The judge has no authority and no power to review whether or not there's a formed defendant at interest. And this essentially interprets the word any to mean none. And none means none. It certainly does not mean any or one of a kind. And this indeed is what many courts who consider
So I want to go back to this earlier question.
Yes,
If this interpretation that you're arguing against frustrates Congress's purpose, why didn't Congress do something about it? Why didn't they take out the and served language? They had the opportunity. They were making changes up and down the removal statutes. Why not fix that one? If it frustrated Congress's intent, as you say.
Your Honor, it's not clear why. However, the deep divide in Congress...
Would you agree it is clear they didn't?
Well, they did change the word none to any, which many courts have held it was an attempt by Congress to enforce the idea that the form defendant rule applies at all times, and that there must be at least one defendant who's properly joined and served prior to removing the case. Now, this is consistent with what courts at the time of 2011 were ruling. Breitweiser notably finds that. Graph on page 8 of the record cites cases that discuss what the majority interpretation at the time was. And there is also a database of over 200 cases which address this specific issue, whether or not snap removal.
So what is the bright line rule? We issue bright line rules.
Yes,
What
sir.
is the bright line rule you're asking us to issue with regard to your position?
Your Honor, the bright line rule that we are advocating for this issue is that the forum defendant rule applies as soon as service of process is triggered. And thus, removal is not proper when the plaintiff has not had the opportunity to join and serve someone, which is what happened here. In the facts of this case, the non-form defendant removed prior to the plaintiff having the opportunity to properly join and serve the forum defendant. So under the rule that the plain meaning approach advocates, the forum defendant is completely insulated from the forum defendant rule. Essentially, all the forum state defendant has to do is relentlessly and vigorously monitor state court dockets, realize that they have been named, and immediately remove, giving the plaintiff no opportunity to have the forum defendant rule apply and the intent of Congress fulfilled, which is to make
the forum defendant didn't remove it in this case. It was the Swiss defendant that removed it, right?
That's correct, Your
Does
Honor.
that make a difference, or should it make a difference?
It should not make a difference. In this case, the non-forum defendant was notified by the forum defendant case. And further, under the plain meaning approach, if a forum defendant were named in a complaint under that approach, they would simply be able to immediately remove, and the plaintiff would have absolutely no power to keep that case in state court. And for these, may I briefly conclude?
You can wrap it up.
For these reasons, we ask the district court to reverse the district court of Texas.
Thank you, counsel.
May it please the court. My name is Jeffrey Gunnell, and I represent the plaintiff appellant, Ryan Wood. I will be addressing the second issue in this case regarding the appropriate test for personal jurisdiction. We ask this court today to reverse the decision rendered by the lower district court and apply the stream of commerce test with regard to personal jurisdiction. We ask the court to do so for two reasons. First, the stream of commerce approach aligns with the realities of modern commerce and comports with due process. Second, the stream of commerce approach provides a fair and equitable result for both the plaintiff and the defendant. Historically, the Supreme Court recognized the need to expand personal jurisdiction. In 1945, in the decision of International Shoe, the Supreme Court expanded personal jurisdiction by allowing defendants to be subject to personal jurisdiction based on minimum contacts and purposeful availment. At that time, interstate commerce was growing, and the Supreme Court recognized the need to expand and did so accordingly. In 1980, in Worldwide Volkswagen, the Supreme Court again recognized the need to expand personal jurisdiction. Today, this court is empowered with the ability to also expand personal jurisdiction. Since 1980, the Supreme Court has provided fractured opinions, applying either a personal jurisdiction test of stream of commerce or the stream of commerce plus approach. The stream of commerce approach requires...
Of what significance are state lines to the approach you want us to take here, if any?
Yes, Your Honor. Each state individually and independently must be able to extend personal jurisdiction based on whether or not it is within due process. Specifically, each state will do that without necessarily regarding whether other states are also subjecting that defendant to personal jurisdiction. The framers were concerned with whether or not personal jurisdiction...
Well, I guess what I'm trying to get at is you seem to want us to conform our constitutional interpretation of the due process clause in this context to the realities of modern commerce, which sell products without regard to international boundaries, much less the state lines. However, we've never said that that's appropriate in the context of our due process interpretation. So how do we reconcile those two things?
Yes, Your Honor. The Supreme Court in Worldwide Volkswagen noted the importance of recognizing 5 separate factors that applied to balancing the interests of due process of a defendant and also that of the plaintiff with regard to state jurisdictional lines. Those were the burden on the defendant in traveling to that forum state, the forum state's interest in adjudicating that issue, the plaintiff's interest in obtaining the most efficient response, the interstate judicial system's interest in the most efficient resolution.
But that's a different piece entirely, isn't it? That we don't even get to that point until we know whether or not we have purposeful availment, a minimum contact with the forum state. So how does that speak into stream of commerce or stream of commerce plus theory?
The purposeful availment that occurs with the stream of commerce test is that they act by establishing a relationship with a distributor that distributes that product to that forum state. The stream of commerce test requires an expectation that that product will reach that forum state. In this case, we have a defendant that knew that that product would reach the state of Texoma. In fact, they contracted with High Sports, who sold over about 50% of their products to 6 states specifically, Texoma being one of them. That expectation provides a result where they have not only acted, but have purposefully availed themselves with the expectation that the product...
Are you coming to the point where you're going to tell me how those factors you just mentioned influence whether we go stream of commerce or stream of commerce plus? What's the connection there? You answered my question by saying there's a connection. So what's the connection?
The connection is that those interests must balance the plaintiff and the defendant. The Supreme Court recognized the need to balance the interests of both the defendant and the plaintiff in asserting personal jurisdiction.
In Asahi, the Supreme Court could not come to a majority opinion on whether or not they would use the stream of commerce or the stream of commerce plus test, but they were able to rule that there's no jurisdiction in this case because of those factors.
Yes, Your
In
Honor.
other words, that means the factors are separate from the purposeful availment question. They're separate questions, so I'm trying to figure out why you're talking to me about those factors.
Yes, Your Honor. Those factors are what balance the interest between the two. Purposeful availment is focused on the actions directed at that state.
Okay, so then back to my question then. What role do state lines play in the contacts analysis, the purposeful availment piece? Because if we're going to let the realities of modern commerce influence how we interpret the minimum contact side of things, it doesn't seem like there are any state lines.
Well, the state lines come into play because whether or not those actions occurred or those actions occurred within that target state. In the forum state of Texoma, plaintiff Ryan Wood was
All right, so Kenyon Coffee Farmer sells 200 pounds of coffee to a distributor in California. And 1 pound of that coffee is sold into Texas by that distributor in California. Makes somebody sick. Forum states Texas. We going to sue that Kenyon Coffee Farmer? Is he subject to jurisdiction in Texas?
No. Did you say that the injury occurred in California?
No, in Texas.
In Texas, if, based on the test, if the defendant knew that that product would reach the state
So
of
he
Texas.
does. He does.
Yes,
He
Your
knows
Honor.
or has reason to know that some small amount of coffee that he sells from Kenya to that California distributor is going to wind up in Texas. Make
Yes.
somebody sick in Texas. He's sued in Texas. He's
Yes,
subject
Your
to jurisdiction.
Yes, Your Honor.
But isn't it your position that Worldwide Volkswagen is binding on this court?
It is in dictum, and yes.
Didn't Worldwide Volkswagen say that isolated sales into the forum state are not sufficient?
Yes, Your Honor. However, that decision was in 1980. The stream of commerce has been further clarified in recent decisions.
By the majority of the court?
No, Your Honor, in concurrence and dissent. However, those opinions have demonstrated the adoption of the stream of commerce because of the evolution of modern commerce.
So Justice Ginsburg on her own has overruled Worldwide Volkswagen, and now an isolated sale is good enough?
Because it aligns with the expectation of whether or not that product would reach that state, the decision in Nicastro, which is what you're referring to with Justice Ginsburg's dissent, that decision was based on specific facts to that case. The scrap metal machine that severed the fingers of that plaintiff was expected to reach that forum state.
If I recall that case, only 4 units went into the forum, and the majority of the court said that was not sufficient.
Yes, Your Honor, the majority in a
That 1
plurality-
unit of coffee would do it,
Yes, Your Honor.
because coffee is more important.
Not quite, Your Honor. Not because of that.
Well, you had me there.
No, the reason for it is if there is an expectation, then that defendant has indeed purposefully availed themselves of that conduct. They have purposefully availed themselves of personal jurisdiction. Regarding public policy and the reason that this best fits, if a manufacturer is subject only to the stream of commerce plus approach, it essentially provides them a playbook on how to avoid personal jurisdiction.
That's what purposeful availment is for, is so I can tell where I can and cannot be sued. Where have I purposely availed myself of the privilege of doing business under a state's laws? That I should be able to predict where I'm subject to jurisdiction.
Yes, Your Honor, but that already happens with the stream of commerce theory, which recognizes the expectation that a product will reach the forum state, and the action of contracting with a distributor to get the product to that specific forum state. The stream of commerce plus
That
approach.
sounds like two different things. Expectation that it is to reach the forum state and contracting with the distributor to have it reach the forum state. At what point do you cross the line into stream of commerce plus?
The stream of commerce plus approach, the playbook that Justice O'Connor gives in Asahi, states that certain things must happen as additional conduct, such as advertising that targets the forum state, perhaps creating.
So when you say advertising that targets the forum state, we have the internet. Everything that the Nigerian company does, Kenyan, the African company does. You should never interrupt someone who's asking a question. My concern here is what we seem to be dancing around is we have a 1980 decision, which doesn't even seem to me to be applicable anymore, given the internet. And again, we're supposed to come up with a bright line rule for everyone. Doesn't every company that advertises for their sales on the internet purposely avail themselves to anyone that receives that internet transmission?
Well, that's the decision that they make when they decide to put their product into the stream of commerce through the internet. Every business has the opportunity to distinguish or decide how they would like to introduce their product into the stream of commerce. For example, a small farmer in Florida does have the opportunity to manufacture a product, but only contract or establish a relationship with a local distributor who would only distribute within the state of Florida.
What if Florida company advertises but says, I don't like Utah, so I'm advertising, but I'm not going to send anything that I sell to Utah, sells it to Texas, under the same theory my brethren suggested, and they send it to Utah. Same person gets sick, can the Florida company be sued?
Your Honor, the question is whether or not there was a reasonable expectation that that product would reach Florida. If within that decision and that contract with that distributor, they elected not to have that product advertised or reach the state of Utah, then no, they would not. That would be a breach of contract on behalf of the distributor. The distributor would instead be reliable for that. And that is...
So the Utah person is denied jurisdiction because of a contract that's executed between two third parties?
Well, Your Honor, that's exactly what the defendants are going to argue. The defendants are going to argue for a test that restricts liability even more than the restriction of the stream of commerce. The playbook that is provided allows them the ability to prevent personal jurisdiction in multiple ways. And by doing so, we incentivize manufacturers to inject defective products into the stream of commerce, further damaging and injuring citizens of each and every foreign state.
Well, how does your expectation requirement, how does the standard work if I contract with a distributor, an independent business, fully independent, and they have the authority to sell the product everywhere or nowhere, wherever they want, and my product winds up in there? I want them to sell as many as they can wherever they want to sell them, but how does your expectation requirement apply to facts such as those?
Well, understanding that their intent is to establish a contract with a distributor that is going to promote that product throughout the United States, they have purposefully availed themselves by establishing a relationship with someone that is going to inject it elsewhere. That understanding and expectation that it will go everywhere demonstrates purposeful availment and allows each and every state to exercise personal jurisdiction over that.
And how is that consistent with purposeful availment, though? I mean, that sounds like the unilateral actions of a third party, which is the opposite of purposeful availment.
Hopefully I didn't misunderstand your question. If I understood your question correctly, it was whether or not that manufacturer establishes a relationship with a distributor who knowingly is going to distribute that product throughout the United States.
I'm establishing a relationship with an independent distributor to sell it wherever you want. Just sell as many as you can.
Yes, Your Honor. That's taking advantage of the entire United States, each and every state individually, and for that reason, that is purposeful availment. Trying to reap an economic benefit from each individual state.
So change the facts of this case. Everything is the same except instead of Ryan Wood climbing and falling in Texoma, he climbs and falls in Utah, where the distributor also sells products.
Yes, Your Honor.
How does that work under your test?
Well, Your Honor, because there's an expectation that the product reach that forum state,
But in this case, the product that hurt him reached the forum state because the plaintiff took it there, not because it was sold there.
But if the manufacturer expects that product to reach that forum state regardless, and the injury occurs in that state, that is purposeful availment. They have subjected themselves to personal jurisdiction within that state. The two-part test does occur.
Help me understand what the minimum contact is that you want us to base the exercise of jurisdiction on. It's my understanding that your client received this product in Missouriana.
Yes.
Okay. Accident is in Texoma. So what exactly is the contact? Because we've got to have this connection. We've been pretty consistent about this. The defendant, the forum, the litigation. So what's the contact here?
Yes, Your Honor. In this case, there's an expectation that the product will be sold in both, if I may briefly
You can wrap up.
answer your question. The defendant is aware that the product is sold in both Missouriana and Texoma. If it was only sold in Missouriana and not Texoma, and the defendant was aware of that, and the plaintiff moved from Missouriana to Texoma and the injury occurred there, that would not subject them to personal jurisdiction. The unilateral activity of a plaintiff does not subject a defendant to personal jurisdiction.
Thank you, counsel.
May it please the court. My name is Cullen Richardson, and together with my co-counsel, Anna Lee Richardson, we represent the appellee, Graycom. we come before this en banc panel to discuss two questions. I will address the first question on removal, and the second question on personal jurisdiction will be addressed by my co-counsel. The District Court and this 13th Circuit Court of Appeals correctly held that Graycon's removal was permissible under the plain and unambiguous language of the Form Defendant Rule in 28 U.S.C. 1441b2. This court got it right on its first review, and for three reasons, we ask the court to once again affirm the decision to deny Mr. Wood's motion to remand. First, the plain and unambiguous language of the Form Defendant Rule prohibits removal on the basis of diversity only if a forum state citizen was properly joined and served as a defendant at the time of removal. And second, application of the plain language of the Forum Defendant Rule is aligned with congressional intent. And third, the plain language, which allows a non-forum defendant, and particularly a foreign citizen, to avoid a potentially biased state court and litigate in a neutral federal forum, does not reach the level of absurdity that is required to override unambiguous legislation. Beginning with the text of 1441b2.
So here's what I want to ask you. In-state defendant, I'm sure you remember this from your basic civil procedure course. In-state defendant waives service under Rule 4D. And I'm sure you remember that Rule 4D imposes a duty upon a defendant to waive service. The in-state defendant agrees to waive service of summons, then removes the case.
Your Honor, removal...
Motion to remand, granted or denied?
Denied, Your Honor. The removal is still permissible under the plain and unambiguous language of the Forum Defendant Rule, and the Third Circuit, which is the only circuit court to have ruled on this issue.
But how do we reconcile that result with this aspect of another federal command, which is that when that defendant is asked to waive service, under most situations, a defendant located in the United States has an obligation to waive service or else must show cause to the federal district court why it didn't. So how do we reconcile those things?
Your Honor, the important thing in this case, and to remember here, is that applying the plain language of the rule is achieving the fundamental purpose of diversity jurisdiction. And even if there's a minor instances where a plaintiff's request to waive service or an agreement among them will not happen, that still does not reach the level of absurdity that's required to override the statute, and the Third Circuit and Encompass Insurance recognize that.
Yes, but part of applying the plain language of the rule is that one statute that you're looking at has to be read in conjunction with the rules regarding service, with regard to the structure of diversity jurisdiction, the fact that it's a removal statute. Aren't you just isolating those words and cutting them apart from the rules requiring waiver of service, like Judge Counselor said?
Respectfully, Your Honor, I disagree with that, and our plain language approach is actually aligned with other statutes in our removal scheme.
Such as?
Such as 1446 states that the notice of removal of a civil action may be filed within 30 days after receipt by the defendant through service or otherwise of a copy of the initial pleading. Here, Congress is stating the words "or otherwise," showing that service of process is not a prerequisite to removal, and this aligns with the plain language approach, which allows Graycon, this non-form defendant, to remove the case prior to removal.
You say your plain language approach is aligned with congressional intent, was I think the way you put it. Well, obviously, if only high sports had been sued, you don't dispute this case could not have been removed.
Excuse me, if they were served?
If only high sports had been sued and served, I mean, if only the local defendant was there, could this case have been removed?
Under the plain language of the statute, it could. However, the issue presented before the court today is the notice of removal filed by a non-form defendant, and 13th Circuit is free to limit its holding to only allow snap removals by non-form defendants.
Let me see if I can improve on my question. You can see that if the defendants had been served, the case couldn't have been removed under your reading.
Correct, Your Honor.
All right. what purpose is served by allowing the race to the courthouse? What purpose is Congress serving with this time interval that you propose?
Your Honor, the Supreme Court has stated in Murphy Bros. Versus Machete Pipe Stringing that service of process marks the traditional point at which a defendant becomes subject to a court's authority. The court recognized that prior to service of process on a defendant, the state court or any court simply has no cognizable interest in retaining authority over that defendant or retaining authority over the case. And therefore, allowing snap removal prior to service of process, based on the plain language of our statutes, presents minimal concerns with federalism. And there are other statutes in our system that also...
You're telling me I shouldn't worry about it, but you still haven't told me what governmental purpose is served by allowing the practice.
Your Honor, in this case, the fundamental purpose of diversity jurisdiction is served by allowing removal to federal court.
Let's talk about the fundamental purpose behind the forum defendant removal rule. Why did Congress create this exception? There is diversity, but when you have a local defendant in the case, why did Congress decide the case shouldn't generally be removable?
Your Honor, it is generally agreed that Congress has decided that the presence of a forum defendant who is subject to the state court's authority through service of process is sufficient to override, if you will, the defendant's desire to litigate in federal court. And
Because it protects the other defendant, right? It's this theoretical presumption that as long as you have a local defendant in the case, the non-local defendant will be protected from state court bias. Isn't that the idea?
That may be...
Isn't that why we have the complete diversity requirements? The same idea, right?
I'm sorry, I don't think I understood.
Just like the
last.
complete diversity requirement is based upon this legal fiction that if you have a non-diverse co-defendant, you have nothing to worry about.
Your Honor, in this case, it is not true that Graycon has nothing to worry about. On page 3 of the record, Graycon is a citizen of Switzerland. They're a Swiss manufacturer with no offices.
Okay, but
no
what's the purpose
employees.
behind the prohibition on removal when you have a local defendant? Let's assume they've been served. Why don't we allow removal?
Your Honor, as the Breitweiser court recognized that because the public policy basis of diversity jurisdiction is still served, at page 8 of the record, complete diversity still exists in this case.
Yes,
And-
but the removal statute says despite that it can't be removed when you have a local defendant, assuming that they've been served, and you agree with that. And I'm just asking you why.
If they have been served?
Yes, if they've been served, why don't we allow removal even though there's still complete diversity?
Simply because after the state court has retained or attained authority over this forum defendant, the rule recognizes that a plaintiff's choice of forum will win out over a defendant's desire.
All right, so here's what I understand you to be saying, that we've got to give meaning to the properly joined and served language in order to have a forum state defendant. If the forum state defendant has not been served, then his being named in the initial pleading doesn't preclude removal, right? That's your position.
Yes, Your Honor.
Okay. But the problem I've got with that is people like your client are electronically monitoring filings in federal court. So they have actual notice of the suit before it is even possible to serve the defendants. So in order to give meaning to the and served language, we have to render meaningless the forum state defendant exception to removal. So I guess my question to you is, what would be left of the rest of the language in that provision of the statute if we go with your view on this issue?
Your Honor, using the words of Wood's counsel himself, he stated that the plaintiff is the master of their complaint. The plaintiff is the dictator. They control their action at the outset. And Mr. Wood here or other plaintiffs can simply join and then serve a forum defendant, and after service has been effectuated on the forum defendant, join and serve a non-forum
No, not if the
defendant.
forum defendant is like your client monitoring the filings. They just removed the case before service. So I ask you again, what's left of the forum state defendant exception other than the and serve language that you hang everything on?
Your Honor, I think it's important to realize that this is still very narrow circumstances in which these defendants will snap remove. The Third Circuit recognized and encompassed that it's in narrow circumstances only where the defendant is aware of an action prior to service and with sufficient time to initiate removal of the action.
But if High Sports, I think the point of the question though, if High Sports just continues to pursue its current practice, it will always be aware of every case that's filed. High Sports will never have the form defendant rule applied against it. How is that consistent with the language? What is left?
Your Honor, the court, again, I would point out that the court is free to rule on the issue that's presented today, and that is that of a non-form defendant removing the case. High Sports, the form defendant, did not file the notice of removal. And understandably, there are concerns on either side of this rule. However, it's important to note that Congress revisited this in 2011 in the Federal Court's Venue, Jurisdiction, and Clarification Act. The legislative history of that act states that it was designed to bring more clarity to the operation of jurisdictional statutes and to identify and delete those provisions that were considered controversial.
What consideration, if any, should we take of the reality of 2019 in which, for example, in the patent world, as soon as a patent case is filed, every lawyer that does patent litigation in America gets notice of it, meaning whoever it is that's sued gets 300 emails from their best friends who are lawyers saying, hey, bad news, you got sued today, which didn't exist in 1980. This wasn't a problem when we started because you didn't know you had been served until you got served. You didn't know you'd been sued until you got served. What, if anything, should this court take any of that change in consideration, or is that just something that Congress needs to address? That it is a totally different world in terms of the ability for companies to have notice of that they've been sued long before any plaintiff can get service effectuated.
Respectfully, Your Honor, Congress has made a decision on this in 2011. In 2005, and Holstrom v. Harrod was one of the earliest of cases, and they cited opinions dating back to 2001, documenting snap removal. And Forest Grove School District from the Supreme Court states that Congress is presumed to be aware of and to adopt judicial interpretation of a statute when it reenacts it without change. Congress in 2011 set out to provide us clarity on following their rules. They're presented with opportunity to add additional language to clarify and clearly show us that they do not want us to follow the plain language as it stood, and they wanted snap removal to be not permitted. However, Congress reenacted.
Weren't those amendments, some of the amendments done to prevent gamesmanship on behalf of the plaintiff and having improperly joined defendants? And so what we're seeing here is defendant gamesmanship, essentially. And so why should we be interpreting the rule the way you want us to whenever Congress has made an intent to prevent gamesmanship in that specific instance with their amendments so far?
Well, Your Honor, the legislative history of the adding of the words "and served" in 1948 does not state a specific purpose for adding those words. However, on page 6 of the record, it's also seen that Mr. Wood filed this action, at least in part, to take advantage of plaintiff-friendly products liability laws. And so,
Plaintiff-friendly product liability laws in the jurisdiction where he was injured and from which the product was sold. That doesn't seem unreasonable to me.
well, Your Honor, we still,
Whichever court it's in, Texoma law is going to apply, right?
Your Honor, I see that I'm almost out of time. May I answer your question briefly?
Go ahead.
Your Honor, even if these results may seem unfair on some sides, an absurd result as defined in Sturgis v. Crown and Shield as a result so monstrous that all mankind would without hesitation unite in rejecting its application. This mild procedural consequence simply does not rise to that level, and we ask the court to once again affirm the decision to deny Mr. Wood's motion to remand. Thank you.
May it please the Court. My name is Annalee Richardson, and as my co-counsel previously mentioned, I will be addressing the appropriate standard for determining personal jurisdiction. The point at which the parties disagree is whether the stream of commerce or the stream of commerce plus approach should be used in deciding whether a foreign company, like Raycon, is subject to a state's jurisdiction. We submit that this Court should affirm the decision to use the stream of commerce plus approach. When a foreign product makes its way to America, the more stringent test should be used in determining personal jurisdiction for two reasons. First, the Due Process Clause was created to limit a state's lawful authority in order to protect the liberty of a non-resident defendant. The Due Process Clause was not created for the convenience of a plaintiff. And second, the stream of commerce approach is outdated in today's international economy.
So I know we can't reach a conclusion about whether or not your client is subject to jurisdiction in this case. We don't have a sufficient record. But the fact pattern here is not uncommon, where you have a distributor, the manufacturer doesn't control what the distributor does with the products, but knows and wants the distributor to sell as many products as it can, in as many markets as possible. So in that circumstance, not different from this one, where are people like your clients subject to jurisdiction?
Your Honor, we submit that by using the plus approach, the individual courts where the suits are filed would have to determine whether or not.
Yeah, but where would that be if we go plus approach? Because common sense dictates there's not going to be the plus. They're going to follow kind of this pattern where they just hand everything over to the distributor and they don't make decisions about marketing. They've designed and manufactured the product that's injuring Americans, but where would they be subject to suit if we adopt a stream of commerce plus approach?
Your Honor, this individual state court would have to look at plus factors, and I understand that using a distributor to send a product nationally would seem as though it would completely let defendants escape liability altogether, but
it does seem that way.
But it's not necessarily true. And
that was your client's intent, though, right? Isn't that what the record says?
Your Honor, it was, but we should not look at this as something that is negative. All corporations limit their liability. That is something that all businesses hire lawyers to do, is to limit their liability and protect their clients in any way possible. And
limit but not escape.
Correct, Your Honor.
So the question is, how would justice be done? How would that defendant be held accountable? For example, is the presence of the retailer a sufficient protection to the consumers of America or not?
Your Honor, the court would have to look at the factors discussed in Asahi and even other plus factors to determine whether or not that specific defendant is subject to jurisdiction. They would look at advertising and marketing in the forum state, designing the product specifically for that state.
Yeah, but as my colleague said, they have lawyers on their side that know all of that. They're going to be smart enough to avoid doing those obvious things. So how do we hold a manufacturer who sells a defective product in the United States through a distributor to be generally distributed throughout the country? How do you hold them accountable for their bad acts?
Your Honor, we have to, like I've said earlier, we have to look at the plus factors, and by not doing so, we are ignoring what the Due Process Clause invokes. And there might be a way, by using a distributor and following all these things, not doing any of these plus factors, to completely...
Why does a foreign fictional entity have any due process rights?
Because the Due Process Clause states that that all defendants must be protected by their liberty must be protected by due process of law. And the due process, as outlined in these products liability cases by Worldwide, Volkswagen, Asahi, McIntyre, state that the defendant, even if it's a foreign defendant, must have minimum contacts with that specific state in order to show that there's been purposeful availment and to subject them to suit in that state.
Okay, let me ask you a different question. It seems to me that there may be a way, this is a thorny constitutional issue. The Supreme Court tried to get it right in Asahi, or tried to come to a decision in Asahi, couldn't have a majority opinion. Same thing in the McIntyre case. So don't you think it's true that we could probably avoid having to decide between the stream of commerce and stream of commerce plus approach, because the facts appear to meet both standards? you have a distributor in the forum state. Doesn't that meet O'Connor's test from Asahi?
Your Honor, O'Connor's test from Asahi does state that using a distributor in the forum state would be a plus factor that would be looked at. But we're not deciding, like you said earlier, whether or not Graycon is subject to suit here. And in some cases, if Graycon was sued in Hawaii or Alaska, we would have to look at those plus factors to determine whether they're subject to suit there or
But
not.
it seems to me that it is prudent to avoid decision on a constitutional basis if we can. And so if you're placing a product in the stream of commerce with awareness that it will reach Texoma, and your distributor is in Texoma, based in Texoma, whether we go stream of commerce or stream of commerce plus, the answer is we've got a contact here. So why would we unnecessarily make that decision on a constitutional basis?
Because, Your Honor, this decision today this decision affects more cases to come. And so by going, I don't believe there's one way to go down the middle. I think that the stream of commerce lays out that they have to put it in the stream of, place the product in the stream of commerce and have an expectation.
Well, actually, what you just said is what scares me the most, which is legislatures will often react to what we do. And if we announce a rule that would allow a foreign company, let's say who makes penicillin, to ship the penicillin to Texoma and say, but just so everyone understands, we're not liable in Texoma if we screw up. Why doesn't the legislature say, well then, foreign company, you don't get to sell in Texoma anymore, and ban the product altogether if you're going to tell people that they can be the citizens of the state that they can be injured and have no remedy.
Your Honor, first I want to point out that the 4th, 6th, 9th, and 11th circuits have all decided to use the plus approach.
I think you're avoiding my question. We have to deal with the reality that legislatures may respond to what we decide. And it sounds to me like your bright line rule is that a company with good lawyers, like you said, can say, people at Texoma, buy all the penicillin you want from us, good luck.
Your Honor, we are not arguing for a bright line rule necessarily. The plus factors that Justice O'Connor has laid out, plus more, as in taking into account the internet in today's current economy, will be factors that would have to be looked at. It would be a fact analysis on a case-by-case basis. So what we're saying is that the legislature, you're concerned that the legislature would be concerned with the decision here today. I don't think it's as big of a problem because the fact that it isn't this bright line rule, it's just an added step to the stream of commerce analysis that will have to be made.
Counsel, let me take you in a slightly different direction. I'd like to, for just a moment, have you address the elephant in the room or the Audi in the room. You cited Worldwide Volkswagen a few minutes ago, and I was really excited to hear that you thought that was binding precedent on this court. Wouldn't you agree that the language in Worldwide Volkswagen completely obliterates your whole entire argument?
Your Honor, I'm not arguing that the stream of commerce approach in the Worldwide Volkswagen dicta is binding on this court.
Why isn't it binding on this court? And why do you call it dicta? What's your definition of dicta?
The Worldwide Volkswagen's holding in that case was that the unilateral activity of a third party bringing a product from one state to another could not create a minimum contact.
Well, that was some of the language in the opinion, but there was other language in the opinion. The famous language about how minimum contacts have to demonstrate that the defendant reasonably anticipated being hailed in the forum. That's binding language of the opinion, isn't it?
Your Honor, in
Is that binding language?
Yes.
The reasonable anticipation, is that binding?
Well, Your Honor, it's...
Because in the very next paragraph is when the majority, the supermajority of the Supreme Court declared that companies like yours, when they engage in conduct where they anticipate within the stream of commerce their product being delivered into the forum state, that there's no question but that minimum contacts exist. That's binding authority, isn't it?
Your Honor, the Third Circuit in Cybergenics Court v. Chinery stated that dicta is not binding on courts.
Why is that dicta? Because the court set out that standard. That's the constitutional standard. And then the very next paragraph, the court said, but this is not the case as to these two defendants. The court gave us the standard and applied it. Since when is that dicta when the court tells us the legal standard?
Well, Your Honor, the 4th, 6th, 9th, and 11th circuits have said that the worldwide Volkswagen dicta is not binding.
And how many disagree with those circuits?
The 5th, 8th, and 7th circuits disagree and use the stream of commerce approach. But if you look at these cases where they use the stream of commerce approach, they are actually using a plus analysis. So, for example, in the 8th Circuit, in Anderson v. Dassault Aviation, the 8th Circuit has said, and in that specific case said, we use the stream of commerce approach, and because the product was placed into the stream of commerce, this defendant, Dassault Aviation, is subject to personal jurisdiction here. However, the court then, to justify that result under the Due Process Clause, looked at the facts that the defendant marketed to the state of Arkansas on their website using photos, using historical documentary of why they sent their products to be finished in the state of Arkansas. The court looked at all those factors and stated that because of this was another reason why they were subject to suit in the state of Arkansas. So this just shows that these circuits that don't agree with the stream of commerce, or that use the stream of commerce approach, are actually giving plus analysis to justify why those defendants should be subject to personal jurisdiction.
Shouldn't Justice Breyer's concurring opinion in the Castro be considered binding precedent under the Marx rule?
Your Honor, looking at the Marx doctrine under and looking at McIntyre, we look at the majority and the concurring opinion. However, what we are arguing is that because Worldwide Volkswagen stated the stream of commerce in dicta, that we do not necessarily have to go with that as the binding precedent. The controlling precedent
Was
under
Breyer's opinion dicta also?
No, Your Honor, but it
Because
wasn't.
I'm sensing a recurring theme here.
No, Your Honor, it was a concurring opinion. However, we must decide between the two tests.
And it was the narrowest concurring opinion that supported the majority decision, right?
Your Honor, the concurring decision in that opinion stated that they agreed that the defendant was not subject to personal jurisdiction, and they declined to decide on a test because they didn't believe that the factors
Actually,
were...
what Justice Breyer did is he declined to state a new test, and he repeatedly cited and quoted from Worldwide Volkswagen, did he not?
Your Honor, I believe that in reading that case, that he argued about the foreseeability of a defendant's products making their way into a specific state court. And so, to me, adopting the plus approach from the majority of that court's opinion, or the plurality opinion, would not be a huge leap from going from the stream of commerce to the stream of commerce plus theory. And like I said earlier...
But that's not how Marx tells us to read the opinion, is it?
Marx tells us to pick the test that does not stray from previous binding authority. And our argument is that there was no previous binding authority. And I know you believe that the dicta would be binding, but we argue that it is not, and that the plus test is not a far leap from what the...
Counsel, you say it's not that far of a leap. However, in this exact circumstance, it is the deciding factor of whether the defendant can be in court or not. It seems like a pretty big leap to deprive a plaintiff their day in court whenever they've been injured by your client.
Your Honor, we are not arguing that our defendant will not be liable whatsoever in Texoma State Court. We are only arguing about what test should be used, and that is why I reiterate that it is not...
But if we adopt your test, then your client wouldn't meet the stream of commerce plus approach.
That is not necessarily true, Your Honor. There's more facts to this case that aren't present in our record that the court will have to look at to determine whether or not Graycon is subject to suit in Texoma. And the U.S. imports $2.4 trillion worth of foreign products annually. And as seen on page 4 of the record, High Sports has made from $200 to $250 million from selling Graycon products. And so this shows just one instance of how beneficial these foreign products are to our economy. And as opposing counsel continued to argue those extra factors that should be looked at, the Bristol-Myers Squibb case cited that even if a defendant would suffer no inconvenience from litigating in the forum state, even if the state has a strong interest in the litigation, even if the forum state is the most convenient location for the litigation, the due process clause can still act to divest the state of its power to render a valid judgment. And so, in conclusion, to more appropriately adhere to due process and to promote our international economy, we ask this court to affirm the decision to use the stream of commerce plus approach.
Thank you, counsel. Counsel, you have 2 minutes.
The United States Supreme Court in Lumberman's case.
Counsel, can you solve your client's problems and get justice for your client by pursuing a claim against the distributor without worrying about whether you're able to obtain jurisdiction over the foreign manufacturer?
Potentially no, Your Honor, and that is the concern.
Potentially no or no?
Depending on the distributor, Your Honor. The rule that the appellees are arguing for today does preclude plaintiffs from the ability to seek recovery from injuries based on defective products from these manufacturers. Specifically, there are 34 million injuries annually from defective products, yet they seek to ask for a rule that would preclude liability completely.
They ask for a rule that to protect their client, which is the foreign manufacturer. But that foreign manufacturer has appointed a distributor here in the United States. And I know you tried to talk about equity in your presentation. What I'm just trying to understand is, do you not have a recourse beyond having to worry about getting service on or jurisdiction over the foreign manufacturer?
No, Your Honor, the
Why
laws...
do we have to change or clarify the rules of jurisdiction here in this instance?
We do not have to change the rules of jurisdiction, Your Honor. We simply have to apply the appropriate test for personal jurisdiction. Distributor agreements and the laws with distributors are different from that of manufacturers and more difficult for a plaintiff to be able to recover. In asserting the stream of commerce plus approach, it incentivizes manufacturers to create dummy distributors who then are sought for liability, but upon liquidation, that manufacturer will simply create a new distributor, essentially evading liability at all times.
I assume there's nothing in the record that I missed, that this is a dummy distributor, that it doesn't have insurance, that it can't respond, etc.
No, Your Honor, but the decision today will incentivize manufacturers to act accordingly. Thank you, Your Honors.
Thank you. The case is submitted.
All right.
You may be seated. I will keep you only for a few seconds before I give you our verdict to tell you that if I had been a tenth as good as any of you all were when I was in law school, I don't think when I left the practice I was as good as you guys are. That was a truly phenomenal round. I think I'm speaking for all of us. I was unbelievably impressed, and so it's a shame that someone is not going to win, because I thought that was just overall a great performance by everyone, and I know that that's shared by everyone up here. But someone does have to win. That's the way the system works. And we found that we would fine for the appellant and we would reverse. So I got that right. Yep. No, I'm kidding. No. Yes, we found for the appellant. Again, it was as close as the Duke game was last night. It was the talent was exceptional on both sides, and the school should be very proud. If you guys are typical of what this school is producing, then they're doing a phenomenal job here. So I think everyone Ought to give them a round of applause. And with
All
that,
right, thank you.
thank you.
And before we turn it over to Allie, Olivia, and Manny, Neil, I see 3 Rebuttal partners in the room. Could you please introduce your partners?
The old guy on the left is David Kent. Jude Hicklin in the middle. Vance Woody to the right. Vance and David came down, I know, and judged semifinal round, I
That is
believe.
correct, yes.
But just Rebuttal is just so proud to be a part of this, and we are glad to meet y'all.
Once again, thank you so much. And thank you very much. Olivia, Manny, it's your show now.
Like he said, congratulations, you guys. That was amazing. So as you know, we have a few awards to give out, and I'll start with the Top 10 Speaker Awards. And I don't know if this has ever happened in history of Moot Court, but we actually had 3 separate ties. So what I typically do is, you start from 10 and then you go up to the winner. We're going to start with 9 today because we actually had a 3-way tie for 9th place of the top 10. And in no particular order, obviously, because it was a tie, we have Seth Wynn, Connor Sheets, and Alicia Warmond. And if you guys could just come up here, we're going to get your picture after we announce the full group of you guys. Our next tie was for 7th place. It was a 2-way tie between Mackenzie Spike, I'm sorry if I said that wrong, and Jessica Cox. And then in 6th place, we had Andrew Swallows. 5th was Sky Schoolfield. 4th was Audrey Edwards. 3rd was Cody Carter. And we had a 2-way tie for 1st place between Amanda Wayne and Jeff Gunnell. So congratulations, you guys. Where are they? Like I said, you guys can go ahead and come up front because we're going to take your picture like right now, if you don't mind, please. And then next we're just going to announce the semi-finalists, which is no surprise, but we're just going to do the same thing. We're going to get you guys to come up here and give you your plaques and take a picture. So from Team 22, we had Emily Saunier and Miles Moody. And Team 29, Victoria Filoso and Maria Moore. So good job, guys. And finally, as you guys just heard announced, congratulations to our finalists, Annalie and Colin Richardson, and our champions, Jeff Gunnell and Austin Byram. So great job, you guys, and thank you for being an attentive audience, and most of all, thank you to our judges.